Welcome to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Today, it's John Janis. John is an AV preeminent peer review rated personal injury lawyer and is the 2015 Plaintiff's Lawyer of the Year by Best Lawyers in America. John answers your questions about the law and how it affects you.
What is litigation?
Litigation is a very generic term that is used to refer to cases that are brought in court for any purpose and the process of the case beginning and the case ending. Everything in between those two is generally referred to as a litigation.
What's the process in a personal injury case?
The process generally involves a multitude of events taking place, is a way of thinking of it. The first thing that happens in a personal injury case that commences a lawsuit or a litigation would be the filing of a complaint against the person or entity that caused the injury in question. That person then has to be served with that complaint, which is to say they just have to be given a copy of it by a process server, and they then have 30 days to file an answer. Once that answer is filed by the lawyer for the defendant, then the case is considered at issue, and the courts are generally instructed to hold a status conference within 90 days of that date for the purpose of setting a trial date. And once the trial date is chosen, the court will also impose some pre-trial deadlines that everyone needs to comply with. But the trial date is what everyone is gearing up for. And the process of preparing for the trial is called the discovery phase of a case. And that's where you're spending a lot of time in dealing with litigation, is the preparing for trial.
What is arbitration and mediation, and is there a difference between the two?
Yes, there's a definite difference between the two. Those are generally known as alternative dispute resolution processes, or ADR for short. And basically that means it's not being litigated, we used that term before, in court. Instead, it's being litigated outside of the courtroom process. Arbitration is basically having the dispute decided by someone other than a jury, and it's outside of the courthouse, like a private lawyer or a retired judge or a panel of lawyers or judges. But the decision in an arbitration context is binding on the parties for the most part. And it's sort of like a mini trial where the rules of evidence are somewhat relaxed and the time frames are a little shorter than they would be in a lawsuit that heads to a jury trial. A mediation, on the other hand, is simply put a formal effort at trying to settle a case. A mediation involves someone being hired to serve as a mediator and then go to the date of the mediation, basically all parties to come to the same place, be put in separate rooms, and the mediator just go between the rooms, ultimately, to try to reach a settlement. There is nothing binding about a mediation. It's simply an effort at settling. And it is usually considered confidential as well, so that nobody can use what happened at the mediation for any purposes connected with the case. If the mediation succeeds at settling, then the case is over. If it doesn't, however, the litigation goes back into play and just keeps going forward. So arbitration is a binding, mediation is not.
What is discovery?
Discovery is pretty much what it sounds like. It is each side's opportunity to engage in ways to discover what the other side's case is about, to get a preview of coming attractions, sort of thing, for what's coming at the trial. There are various forms of discovery. We have written discovery. In other words, lawyers would send written questions or written requests for producing documents to the other side, and they have certain time frames and rules by which they need to follow to respond to those. Another method of discovery that's very commonly used are depositions, and which sounds like a fancy term, but it's really nothing more than taking live testimony from a witness outside of the courtroom setting, outside of the trial setting. Our court reporters are hired to come to the office, and to essentially prepare a transcript of all the questions and answers that are asked at a deposition. Those are the most common forms of discovery.
How long does a case last?
That's going to vary from state to state, but in Idaho, even in Idaho, I should say, it's going to vary from county to county, and it actually turns on a lot of individual facts associated with the case. The most notable of which is how long is the case going to need to be tried? How long is it going to take to go through a trial of the case? The courts, generally speaking, a judge will have an open window for a 3-day jury trial, for example, a lot sooner than they would have of a window for a 3-week trial. But if you want to just come up with kind of a rule of thumb, neighborhoodish, a litigation of a civil case will generally take somewhere between 12 and 18 months on average.
Are there jury trials?
Of course. We in America have, as one of the touchstones of our legal system, such that almost defines our legal system, is the jury system. The jury is basically of a jury of your peers to decide disputes that are brought in lawsuits. In the criminal context, there is a constitutional right for criminal defendants to have a jury trial, in fact, a speedy jury trial. Juries also decide civil disputes, however, and in Idaho, we have a rule that allows a jury of 12 to be appointed, and a 3/4 majority verdict is enough to give you a binding verdict. That is 9. If you can get 9 of the 12 people to agree on a verdict, that's a binding jury trial result.
Can you appeal a decision?
Yes, we have in Idaho several levels of appeal, probably the two most notable of which is the Idaho Court of Appeals, which is a 3-person panel, and then above them is the Idaho Supreme Court, which is a 5-person panel. The question of when can a case be appealed is a legally very complex question that would have to be analyzed by a reasonably seasoned lawyer to decide whether or not there's a reasonable chance of prevailing on appeal. Is it raising a new question of law? For example, is there something that happened in the district court proceedings that seemed to be a legal error of some sort? Or did the jury screw something up? Things like that. So yes, this cases can be appealed, but it is a very big decision to make because it's not cheap and it is a lengthy process. And so not every case is appealed by any stretch.
Thanks for listening to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Join us next time as they answer your questions about the law and how it affects you. They can be reached at 208-343-7510 or hepworthholzer.com.